When an appellate case is finished and decided on, it not only represents an outcome in itself, but it also serves as an example for court cases in the future, and may even wind up creating and modifying the law. You might have noticed this on film and TV. When an attorney dramatically unearths a Party X versus Party Y decision from years past to support their case. Well, law that is established by the outcome of former court cases is called case law. This body of law is different than statutes, which are laws derived from legislative acts. For example, the legislature passing a law that says stealing is illegal. Statutes are inherently more set in stone, whereas case law is constantly changing and evolving based on how cases have played out in court. Specifically with precedents, past decisions of a court cited as authority to decide a similar case. Lawyers call this legal principle of determining litigation according to precedent stare decisis, Latin for stand by things decided. When looking at previous cases, the focus should be on the portions containing the facts and the holding. The holding is a legal term meaning the final decision and the explanation of that decision by the court. Only the reasoning that is actually necessary for the court's decision qualifies as the holding, and only the holding has value as precedent. Statements that are not necessary for the decision are called dicta. Other courts are not required to follow dicta, only holdings. Decisions made by higher courts, such as appellate court, are automatically binding in lower courts in the same jurisdiction. This system of treating cases as a source of law is called a common law system, something we inherited from England. Many other countries follow a civil law system, where only statutes are allowed a source of law. In those countries, how other courts have decided an issue is pretty much irrelevant. So what you learned in high school civics, that only the legislative branch can make laws, isn't quite true. Judges can and do make laws in certain situations. Of course, the most famous example is the time the U.S. Supreme Court interpreted the Constitution to conclude it had the right to void acts of Congress as unconstitutional. Something the Constitution doesn't actually say, but that's a story for a different time. Dealing with case law means dipping into a deep well of court history. Legal U's resources are there to illuminate your search. Legal U, where you are your own best lawyer.